Georgetown Law Federalist Society. This series, as you know, is dedicated to Daniel Webster, one of our nation's most revered orators in public service. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of the Constitution. We are deeply grateful to the Federalist Society and to Georgetown Law for making the Daniel Webster debate series a reality. Tonight, our resolution, you can see behind me, is Does America have a unitary executive? To discuss this important question, we welcome outstanding debate panel. And to introduce the members of this panel, I welcome up here our chapter's Chief of Staff and future clerk of our moderator this evening, Chris Abbott.
Thank you, Ian, and good evening, everyone. And welcome to our esteemed panelists and participants in tonight's debate. We're so grateful to have all three of you. I think we really have a tremendous set of speakers for tonight's event. So starting with the Honorable Paul Ray. Paul Ray serves as director of the Thomas Rowe Institute for Economic Policy Studies at the Heritage Foundation. Previously, he served as administrator of the Office of Information and Regulatory Affairs in the White House's Office of Management and Budget. Before his time at OIRA, Mr. Ray served as counselor to the U.S. Secretary of Labor and was an attorney specializing in administrative appellate law. Mr. Ray is a member of the Executive Committee of the Federalist Society's Administrative Law Practice Group and is a graduate of Harvard Law School. He began his legal career clerkships for Judge Deborah Ann Livingston of the Second Circuit and for Justice Samuel Alito on the United States Supreme Court. Professor Jed Sugarman is a professor of law and the Joseph Lipset Scholar at Boston University. Before serving as member of the BU Law faculty, Professor Sugarman was a professor at the Fordham School of Law. He is the co-author of amicus briefs on the history of presidential power, the Emoluments Clause, the Appointments Clause, the First Amendment rights of elected judges, and the due process problems of elected judges in death penalty cases, among others. His scholarship has been featured in prestigious journals across the country, including the Stanford Law Review, the Harvard Law Review, the Penn Law Review, and many others. And he's a graduate of the Yale Law School, where he also received his PhD in history. And finally, our moderator for tonight's event, the Honorable Stephen A. Vadum serves as a judge on the United States Court of International Trade. Before joining the court, Judge Vadum served as the General Counsel of the United States Department of Agriculture, where he also served as a member of the board of the Commodity Credit Corporation, a government corporation devoted to helping American agricultural producers. In the private sector, Judge Vadum worked for two law firms, Jones Day and Patton Boggs, serving as an appellate litigator and as part of the firm's political law practices. Judge Vadum graduated from Yale Law School and clerked for Judge Julius Smith Gibbons of the Sixth Circuit and Judge Samuel H. Mays, Jr. of the Western District of Kentucky. So please join me in welcoming our speakers. Now let's turn it over to Judge Vadum for some opening remarks.
Well, thank you all, and it's wonderful to be here at Georgetown Law School as a part of this Daniel Webster debate series. One thing that wasn't mentioned is Brady, who is the chapter president this year, was my intern about a year ago. And I think while he was interning for me, he had like 3 or 4 other jobs, if I recall. So it does not completely surprise me that on taking the reins here at Georgetown, he decided to have a debate series that basically has every week of the calendar already blocked off. That seems to be right in tune with how he likes to be kept, and that's busy. So I'm very glad to have Chris here as well to start clerking for me next year. It's good to have these connections to Georgetown. And although, of course, the topic that we're talking about tonight is not necessarily specific to trade, I would be remiss to be here at Georgetown and not to point out that every year, in May typically, your law school hosts the Georgetown International Trade Conference, at which many judges of my court, as well as practitioners in the area of international trade, come to learn and debate current issues that are working their way through our court and the Federal Circuit, and also the agencies that handle the international trade docket, like the Commerce Department and Customs. So if you do have an interest in international trade law, you are at one of the best law schools in the country. to immerse yourselves in that debate. And I encourage you to mark your calendars for May when that conference will once again be held here. But tonight we are here to talk about the unitary executive theory, and we've got two outstanding participants who are going to have some unique and in some cases non-traditional views about how to approach the question that we've been asked here to discuss. So since we've got some non-traditional tracks that may be going down tonight, I want to at least give you a traditional framework from which to think about the topic of the unitary executive. When we're talking about the unitary executive, the question that we are basically asking is, what did the Constitution give the president when it gave him, quote, the executive power, which Article 2 vests in the person of the president? Usually, when we are talking about the unitary executive power, we are frequently talking about it in the context of the president's authority to dismiss other office holders in the executive branch. Because after all, the president's ability to fire someone would appear to be one of the most important tools in his toolbox to ensure that his appointees and the other officers of the executive branch are carrying out his agenda. The challenge to whether or not we have a unitary executive comes in the form of so-called independent agencies, which have been set up by Congress and are typically run by a multi-member board appointed by the president with the advice and consent of the Senate. The challenge being that frequently these agencies and their commissioners are not dismissible at the will of the president. Instead, they have a for-cause protection, which is traditionally understood to mean that in order to fire the office holder, there must be something more than the president is unhappy with them and something more closely approximating they have committed some act of malfeasance. In addition, many of these independent agencies are structured so that their commissioners' terms are staggered, meaning that a president can come into office and find himself or herself facing a commission that is responsible for an important part of federal policy that is controlled by a majority of appointees from his opposite political party, and he has no ability to change that until their terms expire. And depending on how long the lapse period may be, one could be deep in an administration before a particular president is able to take hold of a part of the executive branch. This is a form of check and balance that is intra-branch. Typically, we think of checks and balances that the Constitution sets up where the branches check one another. The legislature checks the president. The president can veto bills passed by Congress. The judiciary can review those acts and determine whether or not they are constitutional and ensure that they are properly interpreted according to the terms that Congress has passed. But here, we are talking about an internal check within a single branch. The question is whether or not that is a good idea and what it means for democratic accountability. Now, it is not only the executive branch that has such a check. The Senate is, of course, a part of the Congress, the legislative branch, and it has another famous check, the filibuster. Filibuster is found nowhere in the Constitution, but it is long-standing Senate tradition going back to the founding that you need some number of supermajority to get something through the Senate, except for certain exceptions. And so there has been a lot of debate recently over whether the filibuster is a good idea and whether or not it ought to fall. And I would suggest that the filibuster, like for-cause removal, are intra-branch checks that can be seen to serve a purpose. And the question is, do we think intra-branch checks are a good idea? And does our opinion of whether we think they are a good idea tend to rise or fall with who controls that particular branch of government. So are we being partisan or are we being objective when we're looking at these inter-branch checks? And perhaps another question to consider is, what does it mean for one's view of representative government when the public gives power to a certain office holder, or in the case of the legislature, a certain idea, and the policies that they seek to implement and on which they ran are held up by these intra-branch checks? Is that a good thing? Is that a bad thing? Does that tend to make people more or less trusting of the democratic process and whether they think their vote actually matters? Do we care? These are all questions that I think have to be considered when we're talking about the workings of both the executive and the legislature of our federal government. And frequently, it is often stated by opponents of the unitary executive theory, that is, people who would be in favor of not of being able to create independent agencies, that without these sort of intra-branch checks, as it were, well, the president would just run roughshod over everything. And there would be no sifting, as it were, within the executive branch of good ideas and bad ideas. Well, I served, as was mentioned, in the executive branch of government during the Trump administration. I was terminable at will, or as my commission signed by the president put it, I was able to hold office during the pleasure of the president for the time being, is what they write on there, to put that into words. But I can assure you that in any executive branch, no matter which political party currently heads it, that there are differences of opinion. And a lot of the executive branch's time is spent through a formal or informal policy process to sift through those differences of opinion and elevate up the major clashes that continue to exist as you go up the food chain. During my time in the executive branch, I made some of the most important legal arguments I have ever given. And I say that as someone who has argued in front of the DC Circuit and who, as general counsel, won 2 cases before the Supreme Court. And yet I can tell you that the most important legal arguments that I ever made, the person who made the decision was not wearing a black robe, and I was not in any court of law. And yet it was points of law that were being argued about what the policy would be. As a matter of fact, in one of the most fun meetings of those I ever had, Paul served as the judge. I'm happy to say I won that. But yes, thank you. I'm glad you pointed that out. But I don't want you to think, whatever your opinion on whether we have, or according to the Constitution should have, a unitary executive, that the executive branch, which after all is composed of people, is one monolith, all marching in the same direction. Every president would love that to be the case, but I can assure you it is not, and there are lots of debates going on today, I'm sure, that we don't even know that are going on, but are bubbling up through the policymaking process with the final decision, if necessary, made by the president himself. So with that background, I'm going to turn it over to Paul Ray to hear his thoughts on the unitary executive and whether or not we have.
Can we follow the judge's good lead here and speak from this podium? I'm sure when we come to more rapid fire exchange, we'll be at the table for that. So I'm going to begin by interpreting tonight's question, which seems like a silly thing to do since I'm sure the author of the question was seated somewhere in this room.
What was his original intent?
Well, I'm glad to say that under the demanding standard articulated in Kaiser, I don't have to defer to you. Sorry. I'm not even going to ask. So there are, of course, 2 ways to ask the question, what does it mean to have a unitary executive? The ambiguity is in the word have. Are we asking, do we have a unitary executive at law? That is to say, does the Constitution create a unitary executive? Or do we have a unitary executive today? I go now to 1600 Pennsylvania Avenue. Do I find there a unitary executive? I'm going to interpret the question in the second sense. One, because it's the question I'm more qualified to answer, but two, because I think a lot of our debates today about unitariness in the executive suffer from a kind of muddle about what exactly is the power that today's presidents exercise. So I want to try to get clear on that. So what I'd like to do is propose to answer the question with the following thesis, that the modern president often acts like a unitary legislature, and this imperils the benefits the founders sought from both a plural legislature and a single executive. All right, so I'd like to begin with a proposition that I think really ought to be uncontroversial, and that is that agencies exercise broad discretion to shape policy. Yes, even after Loeb Bright, it's still true. The old Wilsonian vision of administration imagined agencies as technical bodies, engineering the most efficient means to policy goals laid down by the political branches. But as everyone knows, I expect, the reality today is far different. Agencies regularly choose among competing first-order policy priorities, resolving many of the day's most pressing questions. Whether to prioritize energy production or the reduction of greenhouse gases, whether to require millions of people to vaccinate or let them decide for themselves, whether to encourage or impede abortion access, these and many other questions that agencies confront thoroughly resist resolution on the basis of technical knowledge. Instead, they require policy judgments, just as legislation does. Agencies exercise their broad policy-setting powers subject to presidential influence of different sorts. This influence operates through three interlocking mechanisms, mainly: the appointment of personnel loyal to the presidential vision, the issuance of executive orders and other directives, and in the case of non-independent agencies, the use of OIRA review. Presidential influence over rulemaking is, of course, far from total. Regulated industry and public policy interest groups and political appointees and career civil servants, all of these have their say, of course. Nevertheless, presidents can usually get their top priorities embodied in regulations. Confidence in this ability underlies frequent public presidential assertions of regulatory power. Presidents make a show of directing agencies to do this or that because they are sure the agencies will obey. Presidents wouldn't be likely to issue executive orders saying do such and such if the agency was going to say loudly and publicly, make me. Presidents face strong incentives to make aggressive use of their regulatory powers. People hold the president responsible for just about everything that happens on his watch. They also expect him to demonstrate the energy and activism we associate with the word leadership. To meet these expectations, presidents must wring every last drop of power from the authorities of the agencies subject to their influence, and must use it to pursue sweeping changes that can motivate many millions of their fellow citizens to support them. When presidents use agencies' broad powers to make broad economic or social change, they do just the sort of thing we would expect Congress to do. They exercise functionally legislative power. Now, the main argument that I want to make tonight is that this power is shot through with the potential for the kind of factionalism that worried Madison in Federalist 10. I want to begin by saying that I agree with Professor Calabresi and others that the president, because he's accountable to a nationwide electorate, can check congressional factions. He's also well suited to check special interests that may otherwise capture agencies. But though presidents check some kinds of factions, they can create others. To see why, let's recall a famous argument in Federalist 10 and 51. Federal lawmaking will not degenerate into fighting among rival factions because no one faction will be able to muster the votes to exploit their rivals. Rather, to succeed, legislation has to appeal to something that many factions share, and they'll share very little, except for what is good for Americans generally, and the national consensus about what's fair. As Federalist 51 puts it, a coalition of the majority of the whole society could seldom take place on any other principles than those of justice and the general good. Now, this anti-faction protection depends on plurality. Not just the plurality of interest and opinion groups, but also the legislators who represent these groups. After all, the interest of each group is to forge a majority coalition with other groups to exploit those left out in the cold. Diversity of groups will prevent factionalism only if the groups find it hard to forge such a coalition. As Professor Enzalibe has argued, the Constitution's anti-faction protections depend on creating high transaction costs for forming factional coalitions. The key to this is the large number of legislators whose agreement is necessary to make law. For this reason, the very unity the founders knew to be virtue in an executive is vice in the legislature because it radically lowers transaction costs and thus enables easy coordination among factions. Because the president sits atop many agencies whose powers touch nearly every aspect of American life, he finds it much easier to put together a package of measures that advantage an electoral majority at minority expense than Congress can. To illustrate, imagine a bill that addresses auto fuel efficiency, and abortion, and student loan forgiveness, and public disclosure of greenhouse gas emissions, and mandatory vaccinations, and the standard for qualifying as an independent contractor, and the rules for apprenticeship programs. These are all topics addressed by regulations issued by during this presidential term, of course. Now, it may be that some position on these 7 issues commands majority support, but the question is, how would our representatives and senators ever discover it? Each of these issues would trigger varying alignments of proponents, any of whom could walk away from a deal at any time. So getting a deal on all these issues at the same time in the same bill would be a feat of unimaginable complexity. But that's not true for the executive branch. There, officials' hierarchical structure, inability to walk away from the negotiating table, and responsibility to a single person who can decide disputes between them, we might call him the decider, make the executive branch, as the founders anticipated, much more able to reach decisions and coordinate action. So it is much easier for presidents and their teams than for Congress to cobble together a set of faction-driven measures to win majority support. Now, some of these measures appeal to regular old material self-interest, which was, of course, front and center for Madison's focus in Federalist 10. Some of you may have read the excellent book by Kreiner and Reeves, which establishes that presidents, like congressmen, shockingly, sometimes seek to channel material benefits to places they will do the most electoral good. But we'll underestimate the problem if you consider only interest-based factions. In Federalist 10, Madison mentions factions rooted in religious enthusiasm. We might broaden the point to consider ideological factions more broadly. The problem with ideological factions is not that they want to take stuff from others, but rather that they are so convinced of the truth of their vision of the world and the justice of their claims that they easily overlook the truth and justice to be found on the other side. While ideological factions are more nobly motivated than interest-based ones, they can do just as much harm to their opponents. Presidential administrations, though often powered by the most idealistic motives, can be rife with this sort of factionalism. The founders worried that if factionalism infected government, each group of citizens would believe they could expect no justice from the laws unless they are the ones to make the laws. They would therefore find themselves locked in a death struggle for the controls of the Death Star. The hysteria around every presidential election is just what the founders would have forecast as the consequence of making the president a unitary legislature. Briefly, I want to close by suggesting 3 ways the president's legislative function imperils the goods the founders sought from a single executive. First, the president's policy role distracts him and his advisors from core executive functions. Granted an office with legislative responsibility, much of a president's and his team's attention is inevitably pulled to setting policy and away from safeguarding the nation's security, supervising the execution of the laws, and other truly executive tasks. Second, in the absence of an effective separation of powers, legislative considerations pollute the executive tasks themselves. For instance, the founders hoped for an even-handed enforcement of the laws, but presidents with legislative responsibility are powerfully tempted to enforce the law selectively, relying on policies of enforcement discretion as substitutes for legislative action. And third, the president's policy role makes it very difficult for him to represent the American people, as he ought. As the nation's sole executive, the president must at times direct the whole force of the community. To do so requires him, as Jefferson put it in an interesting letter from 1810, to unite in himself the confidence of the whole people. Not their agreement with his measures, of course, but their confidence that he is doing the best he can by all the people, not just a favored few. No recent president has held anything like the confidence of the whole people, and the presidential policy-setting role, which drags presidents into faction fights, seems to me one main reason why. Thank you, and I'm glad we turn the mic over to Jed.
Terrific. Well, first of all, let me thank Brady and Ian and Chris for planning this entire series. I looked in, just checking the website. You have quite a resource here, and we should really all thank them for bringing in so much debate and ideological diversity and engagement with some of the most important questions of the day. So I commend this, and I'm going to go back to BU and say we should do more of this here. So I'm going to steal. Intellectual property wasn't really a thing among except, they put it in the Constitution in Article 1, but I think this is the kind of ideas that I'd like to steal. I'd also like to steal the idea of calling this the Webster series. So Brady, I appreciate that. And given that I am the representative or the senator from Massachusetts, I will claim the mantle of Webster. We have on our panel a Tennessean. So of that era, we've got Judge Vaden, I guess, can play the role of Andrew Jackson, defending presidentialism, defending the myth of presidentialism. I'll get it. And we also, and then I guess, Paul, you get to pick from Clay or Calhoun. So it also turns out that Senator Daniel Webster in the 1830s went back over the history and disputed the assumption of a unitary executive theory over removal. And it was in those debates that there was a question about, well, what did the first Congress do? And that was one of the places where something was coined, the decision of 1789. It had been used earlier, but people go back and they go back and look at Webster's arguments against it. And of course, one argument is, of course, Senator Webster is going to have his self-interest in defending the Senate. I'll talk more about the first Congress in a minute. I can go into lots of rabbit holes here, but I'm going to try and engage and go big picture, and then I'll go into some details. And I have a handout on the screen where I can offer this. And if we have late breaking, you can also take swag home. Those handouts might be ready where they are in the Georgetown printing queue. So you can read up and follow up at home if you'd like. So on this question, first of all, like Paul, I'm going to return to a close reading of the text here. Does America have a unitary executive? And I'm going to do a close reading of the word "does" as a matter of like textualists in the room, the present tense. And I say yes, we either do or that's where we're going, future tense, because the Roberts Court is making it up. The Roberts Court has engaged in living constitutionalism to engage in ahistorical arguments that I'll talk about in a minute that are not consistent with the original public meaning of the 18th century in the design of Article 2. And so I say this as an originalist, but who is actually arguing about original public meaning? I'm going to make an argument that the historical evidence of what Article 1 and Article 2 meant at the time of the founding was not consistent with what the Roberts Court has adopted and signaled even most recently. The most pertinent example of the unitary executive theory is Trump versus United States, and the expansion of these claims of what is core executive power. It's not in the text. None of what's listed in that opinion is a text of Article 2. It is their assumptions about what Article 2 implies. So first, on big picture, I want to make a defense of originalism. I imagine many people in this room might be sympathetic to that, but my defense of originalism is in contrast to what the Roberts Court is doing. The decision Trump versus United States is one of the most anti-originalist decisions that I've seen. In defense of it, it doesn't try, right? If you go back and look at Trump versus United States, there are very few historical arguments. There are what I call vibe originalism, but it's not even vibe originalism, it's just vibes. It's Article 2 vibes. It's a series of assumptions there. Now, the briefs, I didn't file a brief in that case. I filed briefs in other cases about historical arguments. But the historical evidence is overwhelmingly against presidential immunity. So as an originalist, as an historian and as an originalist, let me just briefly make my argument in favor of lexical originalism. So I assigned my students a book about that drew from Scalia's speeches in 1998 called A Matter of Interpretation. I think it's one of the most important books for any law student to read. It includes a series of commentaries that contest Scalia. At the end of the day, Scalia has a reply, and Scalia wins the day, and maybe has won over the years and centuries with arguments for originalism. So basically, one is a theory of law. What is law? What is written law? Once we go from the English unwritten constitution to a written constitution, it emphasizes text and context. So that's how we read written law, is to read the text and understand what those written words mean in context. That's originalism. Number two, originalism is more democratic than living constitutionalism. Originalism goes back to what we the people ratified instead of what 9 life-appointed unelected judges, who we still need to interpret the Constitution, but the text and context of the Constitution as ratified by we the people is more important than any theory of Rawls or common good constitutionalism and what the Pope might say on either side, right? That's more democratic, okay? And then number 3, it limits judicial discretion. And I say this as someone who's never voted for a Republican in my entire life, right? But I've been saying this for years. But that it's really important to, in our constitutional system, to limit judges just making it up. And I'll say, if I were on the court, let me say this here, if I were on the court in 1973, I would not have signed on to Roe versus Wade. But because I don't think the Constitution, I think that's more of a theory, right? As opposed to original public meaning. But I'm a lexical originalist. And just briefly before I get to these points on the presidency, here's the point about Roe v. Wade and also the point about the unitary executive theory. The text and context, if the text and context are clear, you stop there. That's what I mean by lexical. When I mentioned this yesterday, Judge Vaden on a call, which I appreciate, Mr. Ray organized a call for us to talk about this, where I knew that I would actually agree very much with Mr. Ray. I almost signed on to everything he said, almost. But one thing that he picked up on is that it's an order of operations. If text and context are clear, that's the end of the story. Anything else overturns we the people, right? If the text and context are clear, that's what was ratified in 1788, or that was what was ratified in 1868. But if it's unclear, and Article 2 is very unclear, I'll get to in a minute, then we go to other sources. Then we don't just make it up. Then we don't just say, what would Dworkin do? Or what would the Pope do? What we go to is what did precedents say? So I'm not suggesting that the unitary executive theory being wrong means that we can then have Congress create a Secretary of Defense who has that office for life. That is inconsistent with Myers from 100 years ago. I'm barely getting to, so after laying out the theory, let me quickly address a couple of points about the unitary executive theory. So the precedents are fine, and as long as you're going to get t-shirts that say, this wolf comes as a wolf, right? You all know Morrison versus Olson. I stand with Rehnquist and not Scalia. Rehnquist says there's nothing inconsistent with Article 2 in requiring good cause. Why? Okay, so I've got some swag here. Here's an article, I can auction these off, but here's an article, I think it's Brady who's looking at this article, Faithful Execution and Article 2. So what the phrase faithful execution meant, that this is work that we did with 2 co-authors, is faithful execution wasn't just about the Pope. It wasn't religious, or certainly they didn't believe in the Pope, but it wasn't about the king as the head of the Anglican Church. It was actually quite the opposite. Faithful execution was a proto-fiduciary duty, making sure that English officers for the Magna Carta up to American history and the American colonies would act in good faith. And what's similar to good faith is, loyalty and care. If you've taken corporate law, right? This is proto-fiduciary. So what this signals is that presidents don't have unchecked authority. And our argument is good cause is more or less a cousin of good faith. And Rehnquist himself, in Morrison versus Olson, and please note that was a 7-1 decision, not Scalia as this. I think the Federalist Society treats it like that. Dissent was the majority opinion. Scalia in dissent writes, though this wolf comes as a wolf, he's crying wolf. He's crying wolf. That decision is making up a lot of history. I won't go into the details there, but Rehnquist says that there's nothing inconsistent with requiring good cause with Article 2, because argument I would insert there, but it's this extension of it, is it's consistent with faithful execution, and you can, if you've got good arguments, then you can still remove. All right, I do want to get to responses, particularly to Judge Vaden. I'll come back to this if there's Q&A. I agree with Mr. Ray that a close reading of the history of Article 1 and Article 2 points in favor of his main argument against delegation. So I agree. I think you can make different arguments. I don't think it's a slam dunk, but the text of Article 1 says all legislative power shall be vested in Congress. But Article 2 does not have that. It says the executive power. If you trust me, if you open up your pocket constitution. So am I just exaggerating the word all? Don't just trust me. Justice Thomas and Justice Gorsuch make the same move about emphasizing the word all in Article 1 when it comes to non-delegation. Look back at Gundy. Look back at Whitman versus American Trucking. They think all is a big deal in Article 1, and I agree, and I think Mr. Ray agrees. But the word Article 2 and Article 3 do not have the word all. They have the. There are good reasons I can explain for that, why I'm not just being hypertextualist. There's an 85-page article I've written about that called Vesting in the Stanford Law Review. But what I want to close on these 30 seconds, I do want to show you, I'll show you one chart. I would ordinarily have a handout to give you, but what am I doing here? I am going to my handout. And it turns out, Judge Baden, I will get back to my theories of Article 2 and executive power in Q&A. But what I want to show you here, and maybe the handout, you can see all of this, but I dug into the first Congress. So if this is right, if Judge Baden is right, that executive power implied removal, then there would have been more support for this in the first Congress. The decision of 1789 was a myth. Webster was right, and the Roberts Court is wrong. What I showed here, when I went back into the debates of Congress and into the letters, and found that when you actually go back to what they said and when they said it from those debates, the thing that Chief Justice Taft relied on in Myers and what Roberts relied on in Seila Law is wrong. The weak argument is there was no decision of 1789, but I think it's stronger than that. The first Congress rejected the unitary executive theory of removal. So the blue slice there is what you can attribute to being presidentialist. Only nine of the members of the first House. Keep in mind, the Senate rejected it. So already, the Senate rejected it. Maybe they had their own reasons, but there were many members of the first House that lined up why. It's not just that this was interbranch. We already had the starts of what Levinson and Pildes called the separation of parties, not the separation of powers. Washington had a nascent proto-federalist Federalist Party, and Madison was the speaker of wasn't actually the Speaker of the House, but he was the Prime Minister. He's often called by biographers. James Madison was Washington's Prime Minister for that first year or two in the House. And it turns out you can have Madison, but Madison, like Scalia, was very lonely. Wasn't 7-1, but it was something like 40-16. And even so, the blue is a very small minority of the first Congress. And here's the puzzle. It's not even clear that any of them were actually presidentialist. If you read this article, here's more swag, just came out from the Penn Law Review a year ago. The indecisions of 1789, all we really know is that they wanted something to get through the House that could also get through the Senate. I call that strategic ambiguity. If you go back and read the actual text of the statute they passed, it says nothing about their theory of Article 2. Why? Because they couldn't agree on it. If they agreed on it, they would have written it. If you're a textualist, if you're an originalist, you should stick to the history and not adopt and not suggest that America was intended to have a unitary executive. Thank
you. During your remarks, you strongly suggested that the presidency that we have today is not the presidency that the founders would have preferred, not what they intended. And you've painted a picture of a president who is distracted by acting more like, we'll call him a senator rather than a House member, a senator rather than an executive. So you painted a picture of what you think the executive actually looks like today. How do you think the executive should look today if they were abiding by your view of what the founders intended?
Yeah, so it's very easy to think that that the more powers a constitutional officer exercises, the stronger the officer is. But I want to say, as a kind of addendum to my remarks, that I think it's often not true. Precisely because the president wields legislative powers, I try to sort of sketch a few reasons this is true in my remarks. I actually think that he is, in some ways, a weaker officer and certainly a weaker executive than he would be if he didn't have the legislative power. So what sort of president ought we have? Well, a strong executive. We should have an executive who actually is concentrated on seeing that the laws are faithfully executed and defending America's interests at home and abroad. I think that yes, as I said, I sketched a few reasons why I think that the union of the legislative and executive powers actually weakens the president's executive function. I want to add, at a more theoretical level, sometimes it's necessary to have constitutional restraints to allow an executive officer to be strong. And I think the problem with modern presidents is that they've become, in some, not a total, but nevertheless a very meaningful sense, unbounded. And precisely in the unboundedness of their power lies their weakness.
Professor, I feel like in your remarks, you in some ways did the same thing. You diagnosed what we have today. You diagnosed the direction you think it's moving, and you pointed to what you see as faults in the Supreme Court's interpretation of the executive power. So I want to ask you the same question. What do you think the executive branch should look like today if we were following what you think the founder's vision is?
It's waiting for that. So what I think doesn't matter about within my normative view, right? Or it doesn't really, but what it's important with this interpretation is to channel the framers, which is what you're asking. I think that, let me go back to the lexical originalism. I think a lot of this is open-ended. There are some, let me specify a little bit more about the separation of powers. And let me try and do this concisely. Many state constitutions had an explicit separation of powers clause. This was discussed and known in Philadelphia. They opted not to adopt a formal separation of powers clause. That's one explanation. So to go back to Judge Vaden's point in your initial observation, what does the phrase the executive power shall be vested in a president? There are different explanations. One explanation that I disagree with is just the throat clearing. It's just a topic sentence that is just referential to the rest of Article 2. That tends to be the left-wing answer or the anti-Unitarian answer. I think that's wrong. I think the term, and there's also this other theory, more by the Unitary executive theorists, that executive power implies the royal prerogative. That's also wrong. And why do we know that's wrong? It was rejected. Now, the members of the convention said, of course, we are not adopting the royal prerogative. This has been something missed by a number of historians, but it's so it's not the royal prerogative. And then my friend Julian Mortensen has another theory, which is that it's just an empty vessel. All it means is Congress does its job in Article 1. It fills a vessel to execute, and then that's what the president does. The president has the job to execute legislation. I think that's also wrong. It's closer, but it's also wrong. I'm not going to get into any. I'm not going to get into detail here. But one, a co-author and I have more evidence that executive power implied some things, and and we call this article is going to be titled "Implied Republican Executive Power," and this is both from the from 18th century history, and it's from Lin-Manuel Miranda's musical. The second rap battle, Washington and Hamilton are right, but we know that because in that rap battle, it was originally called Pacificus versus Helvidius. That was the, that going old school here. That debate about the neutrality during the French Revolution and the war and the Napoleonic Wars, Madison concedes. Madison's taking the view that the president can't do what Washington did, but he concedes that the president has implied foreign policy powers. So without going into detail, executive power does imply, contra my friend Julian Mortensen, and contra my lefty friends who say that it's just a topic sentence, Executive power implies foreign policy power. It implies the law of nations. It implies some common law interpretation, and those are very significant. So that my view, so Judge Baden, what I'd say is that there are implied powers, but because the separation of powers was not formal, these things are indicated and are worked out functionally. Right. I'm not denying the separation of powers. What I'm saying is the formalistic idea that the separation of powers were fully worked out by the framers is just not historically accurate. So I think the most accurate view of the presidency is it implies certain powers that then have to be worked out over time between Congress and the president and the Supreme Court. And I think Myers, I think a president who has control over faithful execution, I agree with Rehnquist, that can be executed functionally, but with space for Congress to limit removal power and also to legislate limits to that implied foreign policy power.
When we look at presidential systems in other countries, and granted that there's not a gigantic number to choose from. Most countries have chosen to go the British route, where the executive sits in parliament, and because he commands a majority in parliament, he can do whatever the heck he wants to until he loses his majority. But for those presidentialist systems, Poland, France, particularly the Western tradition, the president frequently, you mentioned foreign policy. Foreign policy is the president's thing. That's what he controls. And the legislature, which frequently does have a prime minister as well, the legislature focuses on the domestic policy. Obviously, with the input of the president, and he gets to review the laws and veto them in both France and Poland and most presidentialist systems. But there's kind of a division of power that's worked out. Is that what you're suggesting, Professor? That you think? Obviously, we don't have a prime minister, but do you think that the founders would have intended domestic policy largely to be a congressional exercise, obviously ensuring that the president would support most of it, so he wouldn't veto it? Foreign policy left to the president. Is that what you're seeing?
Let me make 2 points, and I'll make 1 point by a question. Who was the first president of the United States? This is going to sound like a trick question. And if yes,
George Washington.
okay, that's one correct answer. But
somebody appointed beforehand as a caretaker,
okay, so it turns out, so along those lines,
but I don't know his name.
you know,
Could have been a girl.
I guarantee you do know, there are many answers to this question. One name I know you do know is John Hancock. Why? Well, John Hancock was the president of the
Continental
Congress.
Yes.
So at the Declaration of Independence, where as a legal argument, when did the United States come into existence? It was when they declared independence, and John Hancock was a member. It was like the Speaker of the House, but they called that the president. You could also, there's someone named Elias Boudinot, who was president right before Washington, but when the Constitution was ratified. I could give 4 answers here, but the point is, the term president doesn't mean what we think it means now. I feel like I'm quoting Princess Bride. Like, I don't think that means what you think it is, right? Good, I'm glad this audience gets that good taste in movies. So the first answer here, and I can, okay, another rabbit hole I'm not gonna go down. The word president did not mean in the 18th century the word governor or king, right? Those terms, Franklin was referred to in the Continental in the convention in the Constitutional Convention. He was called President Franklin. Why? Because Pennsylvania had a council, an executive council, and among those 5, he presided, but he was first among equals. Hancock was the first among equals. They chose the word president.
In French governance at that time, it was a title of honor that didn't necessarily mean you were president.
Right. So, and the Lord President on one of the English courts was one member of a so the word president just meant presided over a council. So one thing I'm just pointing out, Judge Baden, is we have an imperial, and I think maybe Mr. Ray would agree with this, we have an imperial presidency now, but it's semantic drift of the word president. So the term president and prime minister, I can't unpack that model from what Poland does now. But what I will say is, picking up on this is the second answer, is the framers thought that, that Congress the reason why it's in Article 1 is because in a republic, legislation mattered the most. But they also recognized the exigencies of having to have foreign policy interventions to keep the country safe, right? That's why there was an implied foreign policy power that Madison and Hamilton, Pacificus and Helvidius agreed on that implied a peace power. There's no peace clause. The treaty is not the only way to make peace, but it was vital and crucial to have one speaker announce to England and France, we're neutral. And that's not just because they discovered that in 1793. They knew this, and it's one of the reasons why we had a constitutional convention. So there was a foreign policy power, but here's the key thing. I think the best interpretation is it's similar to the case called Zivotofsky from the Roberts Court, where this is on the side of the president having a foreign policy power, but it was defeasible, right? It was implied to give the president a foreign policy power, but Congress could reverse it because Congress has legislative power. If Congress didn't act, then that's what because Congress hadn't acted and didn't act, Washington could save the country from catastrophe by announcing neutrality. That's not just good, it's also good history.
Paul, I have one more question for you, and then maybe we'll ask our audience if they have a question or two before we close things. But Paul, I heard in your remarks, as you sought to diagnose the current state of the presidency, a concern that who holds the presidency has become too important, and that the location of so much legislative power in the executive branch has raised the stakes for each presidential election every 4 years higher than it should be, and that I thought I heard you suggest maybe that wasn't the best thing for the country. And I'm curious if you could go down that road a little bit more and talk about how when the executive becomes something other than the executive, knowing that we have Professor Sugarman's point about maybe the separation of powers isn't quite so written in stone, but when there's that melding gets to a certain point and the separation breaks down to a certain point, that affects the body politic as a whole in a way that is not good.
Yeah, absolutely. So, what's really, one thing that's really striking in reading the debates at the time of ratification is both the extent of concern among the founders about factionalism in legislation and how unconcerned they were that the president they created could engage in factionalism. Now, in fact, as far as I can tell, there's only a single reference to the possibility of executive factionalism in Duran's debates. It's one of the members of the convention proposes the possibility that if we had a plural executive, that what would happen is each region of the country would send an executive to the executive council, and then if there were an invasion, those members of the executive council would quarrel among each other about which region to defend first. Right? That's the kind of factionalism that we would see. But I think is if you read Federalist 70, there's a really fascinating line in which Hamilton says that the kinds of in describing why the convention had not adopted a plural executive, he says that the benefits of plurality come with certain costs, of course, and an executive can't afford the costs. And here's the key phrase which I'm going to paraphrase: the benefits of plurality, such as Article 1 incorporates, wouldn't do any good for the presidency. And I think that's a fascinating assertion. It means that, of course, and Hamilton anticipated very little possibility of factionalism in the domain subject to the president's control. And the reason the founders would think this is a good thing is pretty clear to see. The founders were gravely concerned about the need for the people to believe that the laws to which they are subject are laws they can obey because they're good laws, not because they're made to do so at the point of the bayonet. Indeed, this is one of the main themes to which the anti-federalists recur throughout their writings at the time of ratification. They say that we need a smaller republic because there it's more possible to understand the reasons for the laws that your legislature is enacting, and so more possible to follow them precisely as laws, that is to say, as directives that appeal to one's own reason rather than as something that's being sort of forced down upon one. So the founders were quite concerned about the possibility that there might be measures adopted that one faction or another thinks are both deeply iniquitous and designed for their harm. I think frankly, that's exactly what people fear when there's a presidential election, right? They fear that the other candidate is going to do a bunch of things that are really terrible from their perspective, and that's it would deeply trouble the founders and should deeply trouble us as well.
I just want to second that. That's the part when I say I agree. This is the thrust of what Mr. Ray is saying is not just true now in 2024. It is one of the founding principles of the fear of an imperial executive or monarchy in 1787.
And I want someone other than the professor to give you a reading assignment. So I will tell you that if you want to read something really interesting about what people feared about what our system of government might lead to, you should read the anti-federalist papers. I recently did that, and it is fascinating from my perspective how many things they got right about what the problems would be. It's also kind of interesting to see some things that they were really scared about which didn't come to pass, like they were scared that the Senate would become all-powerful and tyrannical. It's just kind of funny nowadays that, a body that sometimes can't debate whether or not to turn the lights on would be all-powerful and tyrannical. But definitely you should read the Anti-Federalist Papers for a view from those who dissented from the Constitution about the faults they thought it might lead to with the structure that it set up. But with that, hopefully we've got a question or two and then we can close it out. How about the gentleman over here on the right?
Yes, I had a question specifically for you, Professor Sugarman. You said during your remarks that Article 2 sort of just implies certain powers at the moment of the founding, that then had to later be worked out between Congress, the president, and the courts, and the Supreme Court particularly. To play devil's advocate, couldn't you just say that that's what's happening right now?
Yes.
And I guess, so then I guess if you accept that proposition, then how would you argue against that? Just by objecting to the justification that the Supreme Court is using to develop the law in this direction, by saying they're making things up and not being honest about making things up, or by saying alternatively that they're going beyond what these implied powers were understood to encompass at the moment of the founding?
Two quick answers. One is so I'm with Rehnquist on functional separation of powers. The idea was not just that they would work things out, but at a certain point, right, to interpret Article 1, Article 2, Article 3 is there's not a formal separation of powers clause, but functionally it had to work, and that's checks and balances. One more thing on this is Madison titled those essays in the Federalist Papers not the separation of powers, he titled them the significance of checks and balances, and I'm paraphrasing. So checks and balances is justiciable, it's not just anything goes. So that's one thing. The second thing is you also are shaped by precedent. So that's why I'm saying, hey, even if I think Myers was wrongly decided or wrongly analyzed, or the history in Myers is wrong, Myers is also 100 years old and is precedent that is, Ann Humphreys is precedent, and Morrison versus Olson. Those precedents that are longstanding, I think, get more respect than Seila Law or Trump versus United States.
Wow, something from the late 1980s is long-standing. That's good news for me. So, all right.
Hey,
From the early 80s, so I must really have some gravitas, I'll tell you. We've got a question over here on the left, gentleman in the sweatshirt.
So Gouverneur Morris, as part of the SAL committee, purposely wrote Article 1, all legislative power herein granted, versus the executive power. Why should we not interpret executive power in that common law contour, assuming, of course, that lock-in prerogative theory is wrong?
I addressed this in the article of vesting, and I've talked enough. So go read my article of vesting, cite it, but I addressed that question.
Was there a question over here? The lady in the back.
Yeah, hi. Paul Ray, I've had the serendipitous experience of hearing you speak twice today.
My condolences.
And I missed both meals, don't worry. But the topics were somewhat similar, and I'm trying to reconcile the two discussions. This morning at the Heritage Foundation, it sort of sounded like people almost were reconciled to the notion that there was this really, really large burgeoning executive, and that there were people scurrying around in this executive that may or may not even be representatives of the people, but had power. And I'm listening to you tonight, and almost a description of almost a besieged presidency, that there's so much responsibility and so much to do. So my question is, do you think we're running the risk of a multi-person executive?
I think we're not running the risk that there would be two people called the president at the same time, or three people.
No, but I mean like a sort of a committee circle around an inner circle that's really decisional.
Yeah, no, it's a great question. I'd like to answer the question by imagining a spectrum with the president over here and everybody else over here in the executive branch. And as issues become more politically salient or register on a few other scales, they move further down the continuum toward the president, getting more and more of his attention. There are a few decisions that take up a lot of presidential attention, right? But not many. Most decisions, well, a friend of mine used to joke that the by far the most valuable resource in Washington is 1 second of the president's mental capacity, right? And that's probably true. So most issues get very little presidential attention. They are decided through some mixture of presidential deciding and the decisions of other people, right? At the far end of the spectrum are decisions that neither the president nor anyone close to him nor anyone who could conceivably be said to bear his will decides. And the fact is that the agencies decide many things that are at the far end of the spectrum that no one within any approximation of presidential will ever gets near. But nevertheless, very many very important policy decisions do fall within the presidential orbit. So what I want to say is, on many issues, I think that's a really serious concern to have. Unfortunately, we have to both hold that concern with a concern about a hyper-powered presidency at the same time. So it's a worst of both worlds, I'm glad to say.
Yes.
Do we have one more question to close out on from anyone?
Judge Ray, who do you think was the last president to properly carry out the office in the way you think that it was intended to be carried out?
Well, I'm not a judge, so but
You were in my case, though.
well, fair enough. Well, if we're all picking 19th century lawyers to be, then of course I want to be Lincoln. But I'm sure he wasn't the last president to be the kind of president that we would want. Probably. Well, here's the interesting thing. I actually think it wasn't terribly difficult to be the kind of president we would want to have if you were president before the New Deal, because presidential powers were just a lot more limited. So it mattered who the president
I
was.
was going to suggest Calvin Coolidge.
I mean,
That's who I was going to
it's a
suggest.
pretty good suggestion, and I'm not second you on it. But no, but I think that the broader point is the stakes. With some exceptions, as the Lincoln example shows, the stakes were just lower for a great deal of American history. And so every election just wasn't, or couldn't even make a plausible claim to be a kind of existential event in the life of the country, right? Modern elections may well be, may be existential events. We're a stronger country than people give us credit for, but my goodness, a lot really does come down to the person who lives in the White House.
Can I make one more observation based upon what Judge Vaden, you asked them to read the Anti-Federalist Papers?
Sure.
This is something that's gotten overlooked. the anti-federalists had every reason to point out, every reason to vote against the Constitution. They were also very concerned about the construction of an executive branch for the first time. There is not a single anti-federalist who says, Article 2 implies removal. That's a reason to vote against it. So if no one thought, if none of the opponents who had every reason to interpret Article 2 in a way to be alarmist, they didn't think it implied, and it's, there's a little query I have with another article written that actually doesn't show this, but if the anti-federalists didn't think the president had a risk of having this kind of authority, then it probably means that no one in the founding thought the president had removal.
And I can't resist adding to that. What's really extra absent from the debates is any notion that the president would get to set the kind of policy the president gets to set today, right? I think it's safe to say that the anti-federalists would. I mean, I can't even imagine what their reaction would have been had they been even a whip of such a thing.
They did not predict ALJs, that's for sure. And with that, I want to thank our two wonderful debaters and all of you for coming here today. Thank you so